The Supreme Court cracking down on criminal politicians once again, ordering that trials of lawmakers accused of serious crimes must be completed within a year. If a trial court fails to meet that deadline, it will have to explain its reasons to the High Court. Last year, the Supreme Court had barred MPs and MLAs from elections if found guilty of offences carrying a jail term of at least 2 years.
Political leaders who can no longer use their clout to delay cases against them to prevent disqualification. The Supreme Court has ordered all lower courts to complete trials against MPs and MLAs within 1 year from the date of framing charges. A recommendation made by the Law Commission, an advisory body of legal experts under the Law Ministry. For extending the time, the trial judge will now have to approach the Chief Justice of the concerned High Court. The order comes on a petition by NGO Public Interest Foundation, which wanted charge-sheeted persons to be stopped from contesting elections.
As soon as the new MLAs, MPs come to the Parliament or to the legislatures, they will have to face this order and they will have to stand trial and face conviction.
The court order will affect a large number of legislators, including Jayalalitha, who is eyeing the Prime Minister's post. Tamil Nadu Chief Minister J. Jayalalitha is facing corruption charges. Despite the Supreme Court's order in 2003 for day-to-day hearings, the case is still on. YSR Congress leader Jagan Reddy is also facing a disproportionate assets case, but the trial will have an impact only if he wins a Lok Sabha seat. Suresh Kalmadi, currently an MP, charged in the Commonwealth Games scam. Ashok Chavan, former Chief Minister of Maharashtra, charged in the Adarsh scam. NCP MP Padam Singh Patil, accused of murdering a Congress leader in 2006. Former Karnataka Chief Minister and sitting MLA B.S. Yedurappa is also facing corruption charges probed by the CBI. Politicians cutting across party lines on record welcome the Supreme Court order.
These types of step and action by the courts of our country will certainly help to clean the public life of this country.
राजनीतिज्ञ हों अथवा जितने भी लोग उच्च संवैधानिक पदों पर बैठे हैं, उनके विरुद्ध होने वाले ट्रायल्स में जितनी जल्दी हो सके उसका निस्तारण होना चाहिए और इसके संदर्भ में किए गए किसी भी सुझाव का व्यवहारिकता के दायरे में रहकर भारतीय जनता पार्टी स्वागत करेगी.
On the larger matter of whether framing of charges should be the trigger for disqualification of candidates and not conviction, as is currently the norm, the Supreme Court put off taking its decision, saying with elections around the corner, it would wait for a better day.
Lawbreakers should not become lawmakers. That is the intention of the Supreme Court. The top court recently has passed many orders, including instant disqualification of convicted legislatures. The deadline of 1 year completion of trial against MPs and MLAs may be a great thing, but will it work on the ground level? That's the big question. In New Delhi, Arunachalam Vaidyanathan, NDTV.
So fast-tracking trials of MPs and MLAs, will it actually help clean up the system? Joining us tonight, Dinesh Trivedi, Council for Public Interest Foundation. That's the NGO that filed the PIL on which the Supreme Court gave its order. Joining us from the Congress tonight, Amiben Yagnik. We're also being joined by Kiran Bedi, former IPS officer, and P. Rahul Mehra, lawyer and spokesperson of the Aam Aadmi Party. But Dinesh Trivedi, you are representing the NGO that filed the PIL in this matter. And in fact, what you were fighting for or hoping for was a different judgment in a sense. And that's something that the court has decided not to broach at the matter. But as this step goes, do you believe it's a step forward in the attempt to clean up
it's certainly a step forward and a good step forward. And I hope there would be many more steps. The caravan should continue moving. But we were not hoping for a different judgment as such. Of course, the first issue was slightly different, which was the larger issue of disqualification. But then this was also an important part of that bill, where we prayed for fast tracking of these cases. And that was accepted by the Supreme Court because there was no impediment to it. It didn't require any passing of law or any constitutional amendment. Consequently, it could be directed by the Supreme Court.
But you're still hoping that the disqualification of MPs and MLAs should be triggered at the stage of framing of charges rather than conviction, which is now the norm.
That's what the report of the Law Commission is, and that's what the report of the Election Commission was in '96. Then 2004 report of Law Commission, and then this report of Law Commission, that framing of charge should be the trigger.
All right, Kiran Bedi, come in on this. You've welcomed the court's order today, saying this is a positive step. logistically on the ground, do you believe that fast-tracking of cases is going to be the way forward for a cleaner system?
It's an excellent thing. I think the court found a via media, Ankita, that if you can't do it at the framing of charges, because that was the allegation that it may get trumped up, it may get managed. Therefore, they're looking at fast-tracking. My issue is fast-tracking by which courts? It's first of all absolutely welcome. It was needed. And it will have a great impact on all political parties now. Who do they give tickets to? Because if after getting elected, first of all, it's going to hit the voter. I tell you, people don't want to vote for candidates who have political credentials, who have criminal credentials. I think it's that will be a caution. Secondly, they might just lose it. If they get conviction, then they have to vacate the seat, because that's another judgment of the Supreme Court, that you cannot just keep sitting while the appeal is pending. So therefore, that means the parties will lose a seat. And in the current scenario, every seat will matter. So I think, number one, the caution would be, do not give seats to those who may get convicted within a year, depending on the evidence. So why risk it? So I think, but the key factor is, to my mind, is whether the same courts, will they focus on these at the cost of other cases? I was thinking maybe the courts also say that such courts, the senior court also says that such court may have an evening hour. Maybe we get into evening courts. We may, because you need more time. Otherwise, what about the normal courts?
Right.
We must take into account, but would they be evening courts? Where do the time come from? And third is the Bar Council. What about adjournments? Will the court be tough on adjournments? Because that's where the role of the Bar Councils and the defense lawyers will be very, very vital, besides the witnesses, etc. So I would probably say this at the moment.
But the other sort of logistical problem, really, in terms of, trial courts already facing a staggering backlog of cases, when they're asked to fast-track these particular cases, have day-to-day hearings, what sort of impact is that going to have on the system at large?
Of course, it is bound to have some impact on the trials which are already pending in the courts. And the courts are absolutely full with such trials. But then it's an issue where if we don't do anything, then we are damned. If we do something, then we are damned. Some kind of aberration will always emerge. So the issue is you have got to balance the benefit and the loss out of it. And if you look at it that way, then this was something which is going to cleanse your polity. It is going to sustain your democracy, which is the most basic of things in the Constitution. Therefore, we should allocate some special time for it. Rest, it also depends on the government for allocating more funds so that there can be more courts, more judges, and so on and so forth. That's a long drawn thing. But at the moment, that should be the first nascent step towards cleaning the politics.
Okay, and you see the first nascent steps being taken. Rahul Mehra, let me take this across to you. Do you believe this is also a first positive step, but a lot more that could perhaps be done going ahead?
Well, definitely, it's a very good beginning, I must say. But, I have issues with why only the elite political class should have the benefit of a speedy trial. I mean, speedy trial is a fundamental right of every citizen. Why is it that only the MPs and the MLAs should have their trials finished in a year, while the ordinary citizens of the country languish for decades together? Why is it that the same principle is not going to be applied to the senior citizens, for example? Shouldn't they have a finality as far as litigation is concerned before God intervenes in their life? Why should offences against women should not be as parity?
Mehra, do you see this as a speedy do you see speedy trials as being something that is only going to aid the lawmakers? Because if anything, the concern seems to be that lawmakers have disproportionately delayed their trials for years to come, using their political clout to do so on occasion, so as not to be disqualified. So in a sense, there may be MPs and MLAs who will not be welcoming this order at all.
Sure. So to that extent, I welcome it. And, as far as my political party is concerned, I don't think we have anything to worry out here, because we in any case give tickets to only those people who have good credentials, who have absolutely zero criminal background and so on. But I have a larger point to make out here, Ankita, and which is that, I haven't read the text, so I'm not too sure. And I think this will be in the final print. What happens if there is a charge which has been framed by the court and while the trial is going on, somebody, or before the trial has even started, the accused so chooses to challenge it before the High Court, and then High Court sits in that quashing of the charges petition under 482, or maybe the Sessions Court sits on it in a revision. What happens then? They can sit for years and years, and this is what happens in the courts. If you want to clog the system, don't want trial to go ahead, you go and challenge it in a higher court, knowing very well that your case, since it's being defended by the best of the best lawyers, they will be able to get a stay on the trial, and then it will take 10 years or 7 years or 5 years for the higher court to look into, finally dismiss it. What happens then?
Okay, Dinesh Trivedi, do you believe there are still enough loopholes within the legal system that will allow a prolonging of cases despite this order?
Fair enough, there will always be loopholes, but the fact remains, I can answer my friend's queries. See, the direction is that it must conclude within 1 year. And in the event for some unforeseen strong reason, real cogent reason, the court is not able to conclude the trial within 1 year of the framing of charge, then in that event they will move before the judge of the respective High Court, Chief Justice of the respective High Court, and then get an appropriate order for extension of time. Now, when this kind of direction comes from Supreme Court that it must be concluded within 1 year, then that gives a reasonable kind of a feeling to each and every court that they have to proceed expeditiously.
Yes, Rahul Mehra, you had a rebut. Go ahead quickly.
One would assume that what my friend is saying would be the tenor of the judgment, and that's the way it's going to be implemented by the courts across the spectrum. But practicalities, and we have practiced enough on the criminal side to see how the law is frustrated at every step of the way. So, though it is welcome, but I'm saying there are enough ways to circumvent it even now. And my larger issue still remains as to why other citizens should not have a speedy trial. Why should they languish for years together in a clogged system? What is their fault? And why is it that there should not be equality before law as far as speedy trial is concerned? It's one thing to say that the entire courts are clogged, there is a huge backlog, but then it is for the judiciary, it is for the politicians, it is for the law ministry, it is for each one of them to sit down together, put their heads together, and do whatever is required to be done to ensure that you have enough judges, you have enough courts, and you have a system in place which works rather than which collapses every now and then.
Kiran Bedi, would you agree with that in a sense that, be that as it may, that it may be cleaning up the system at some level, it's also making it rather unequal for normal citizens approaching the courts?
Rahul is right. In fact, there's a very large vacancy across the board of the judges from lower courts to higher courts, or somewhere it's even 1/3. It's a very high vacancy. First of all, why should we have those vacancies? We must get them filled up. There's huge vacancy in the prosecution branches, huge vacancy in the lower courts and in the sessions. It's all low. Somewhere it's very, very high. Therefore, I think this needs to be addressed quickly if you want. Secondly, as I said, I quickly opened up saying we need to look at evening courts concept. Why? And let's compensate the existing judges accordingly. So that means we don't eat into the common man's time. If you want to expedite this to clean up the politics, going for a concept of evening courts, and in many countries, when you want expedited trial, they even worked on Sundays. So why can't we have a sense of urgency in this?
Okay, sense of urgency. I'm told Amiben Yagnik can hear us now. Amiben, let me take this across to you and also put to you the question I was trying to put to you earlier, which is that is the onus not on political parties now to ensure that tickets are not given to candidates who may well just be disqualified a year down the line?
Ankita, there are several points in this issue, and all of them are intertwined. As my colleagues on the panel have said, I think they are absolutely right in their own ways. Because when we are talking about this Supreme Court directive, it is mandatory and it has to be followed. It's a very welcome step to see that there is no criminalization in politics. But if you see that from the time of filing the criminal case to framing of charges, there is an investigation by the police and then the trial within a year by the judiciary, all requires to see it very objectively and in detail, because we need judicial reforms and we need police reforms, because at every stage there is multiplicity. People can go to the higher court, still higher, and at every stage of the application of hearing in the lower court. So this is going to be delayed unless and until we have the reforms in place. We cannot completely wish away that there will be stopping of criminals entering into politics. So it will have to be a very concerted effort by politicians and the police investigating agency to bring in reforms on a very large scale and on multi fronts in order to see that this directive of the Supreme Court is completely obeyed and fulfilled.
Now, be that as it may, Rahul Mehra, come in on this point. Every time matters of electoral reform or matters of criminal candidates come up, we hear the same kind of lip service being paid by the politicians. But at the end of the day, if you look at the candidates in the fray, what does it really say about, when it comes to a winnability versus clean politics debate, which side wins?
Well, the conventional way of politics, the way politics is governed in India over the last more than 67 years, there is absolutely no doubt that winnability is the only factor. There is a factor of a person being popular in a certain place, a person having created a kind of a fiefdom in his own territory, and therefore, in order to grab that seat and to ensure that the seat is in the pocket of a certain political party which has a strong base out there for whatever reason, they would like to go with a tainted individual rather than a clean individual. But hopefully, and I would like to mark the word, this trend has probably taken a reverse side ever since Aam Aadmi Party has come into being, because the Aam Aadmi Party has shown that clean politics and clean credentials are also such kind of candidates can also win, and winnability is nowadays in fact more, because people are getting conscious, they are educated, they want to be aware, they want to know what kind of a candidate is there, whether he has any kind of cases against him. So therefore, I think today it works more advantageous in favor of a clean credential candidate rather than otherwise. But let me just make it clear that if you leave it to politicians, no reforms will ever happen, because they have a conflict of interest and there is a conspiracy of silence to maintain the status quo. So the status quo suits them, and therefore it has to be the courts which have to intervene and ensure that politics, electoral politics, and every reforms, for example, police reforms was talked about. Why is it that the Honorable Supreme Court can't issue contempt notices in the Prakash Singh's matter and call all the chief ministers or the heads of the states in the court? You will see that implemented within 24 hours. It's only that the Honorable Supreme Court is actually letting them go.
Do you believe the law can in fact clean up Indian politics, or does the push have to come from lawmakers themselves? Can't the political class in a sense come together to evolve some kind of consensus that a person, once they're charged by a court for a serious offense, is not allowed to contest, maybe specify what those offenses are? But does this push now need to come from the political classes themselves, or is that just a pipe dream?
I think it's a two-way. It's come at the right time. The judgment couldn't be more timely, because it's a time when tickets are being decided. So the political parties run the risk, if they give tickets to persons with criminal credentials, they run the risk of losing votes. They run the risk of losing the seat one day. So I think it's come at the right time. So each political party will, I think it makes it easier for some of them, even if they're winnable candidates, the political parties now will have a handle to deal with them, to say, look, this is the risk we'll run. Why don't you just work for the party and its work and promotion rather than find the seat? So I think it's come at the right time, even for political party leadership, I would personally think. Secondly, I think the onus is as much on the judiciary to expedite the judiciary. I think they need to evolve a criminal justice system which fills up vacancies and sees that the government also releases funds for the special courts which have been pending. So I think it's also an element of governance and administration, and the role of the registrars of high courts to deal with the district courts, which I think is needing much little more hands-on, more technology use, more affidavit use, less of adjournments, ensure policing and prosecution is in place to bring in faster witnesses so that they can move faster. I think it needs a little more of back-end work, even by the judiciary itself. I don't think judiciary should stop at just giving this direction, which was necessary. I'm so glad it has, but needs to do little more back-end work.